Good morning, and may it please the court. My name is Roberto Garcia, and I'm the attorney for the defendant appellant Willie Brown. And I would also like to say that this is my first time here.
I was going to say, is this your first time before us?
It is my first time, yes it is.
You look new.
I have
Garcia,
filed,
welcome today, then.
thank
Welcome.
you. I have filed briefs before this court, but this is my first oral argument here. And your honors, this case does concern.
Rebuttal? Do you want to save
Oh,
some?
yes, your honor. Can I say 5 minutes for
5
rebuttal?
minutes, sure thing.
Thank you. Judges, in my brief, I raised 4 issues. And one of those issues concerns the admissibility of text messages that I argue were not properly authenticated and that unfairly prejudiced Mr. Brown. I will also argue that the evidence presented at trial was not sufficient to sustain Mr. Brown's conviction of rape of a child. This case.
Is the evidentiary sufficiency essentially limited to identity? Are there other elements that you're challenging?
It's mostly about, yes, Your Honor, not only identity, but there was no any other evidence. There was no other witnesses, there were no physical evidence, and...
Well, the law itself would not require, to sustain a verdict, would not require corroboration of a victim's testimony. And of course, on our standard of review, we have to take all of the evidence in the light most favorable to the state. We have to discard our countervailing evidence, and then look at whether the evidence would be sufficient for a rational trier of fact to find the essential elements beyond a reasonable doubt. So, apart maybe from corroboration issues, are there other elements that you're challenging separate from identity?
No, Your Honor. That would be my main argument as to the sufficiency of the evidence. I'll also say that the text messages that I mentioned earlier did go into proving that Mr. Brown committed this offense, but I will argue that that's also was insufficient for several reasons, and that those text messages shouldn't have been introduced in the first place, and that was abuse of discretion. And that's where I would like to go ahead and start my argument, is those text messages. Those text messages were sent to Demetrika, who is the mother of TG, the victim here in this case. And they relate to Demetrika threats concerning some events that had happened that they were going through. Throughout the entire trial and into sentencing, Mr. Brown denied sending those text messages. When I read the transcripts, Mr. Paul Hutchinson was the investigator on the case. He was working for MPD for 26 years in the 6th Crimes Unit. And his investigation only found that that number went back to a website called bandwidth.com. Now, I don't know if your honors are aware of burner phones or TextNow, WhatsApp, things like that. Those things do exist. But my argument for this case is that those text messages should have never been introduced because that was just not enough evidence to say that Mr. Brown was the one who sent those messages.
Let me ask you kind of a 2-part question. If the text messages had come back to the defendant's phone, no question he owned the phone, no question he sent the messages, do they come in?
I would say yes, Your Honor.
Okay.
That will definitely authenticate.
So with that as the baseline, that there's nothing, the messages in and of themselves, while prejudicial, obviously are not unfairly prejudicial, and they are probative to the case at hand. So as the baseline, if we could prove authorship, that's the baseline. It's okay that they come in if you can prove authorship. You agree with me on that?
Yes, Your Honor.
Okay. So the state makes the argument that authorship was proven by the fact that whoever sent the messages referred to the victim's mother by a name only that the defendant referred to her by.
By 2 names even.
Yeah, by two different nicknames that only the defendant referred to her by. And that the defendant, and maybe I'm giving the state more credit than they wrote, but basically the defendant the way he talked about the crimes, kind of only the defendant would know about that. So it's a nickname that only the defendant knows, and then the way he kind of at least talks about the victim and the crimes, really only the defendant would know that. Is that true?
Well, the defendant, if he had committed the crime, and also, of course, the victim, TG, which during trial, the defense was raised that TG was making this up. She was trying to get out of trouble. She had been punished before. She didn't want her mom going through her phone. So it's possible that she might have been the one who sent those text messages. I know there's a very limited number of people who could have known about this offense, but I will also argue that
So was that argued to the trial court that, look, Your Honor, we recognize, the defendant knows these names and the defendant knows about the facts if he committed them. But the other person who knows about the facts and who would probably know the nicknames would be the victim.
yes.
And that was argued to the trial court. And how did the trial court resolve that type of argument? I mean, obviously, he resolved it by denying your request, but I mean, what was his rationale for saying that they proved authorship?
I believe the trial court stated that due to what you've stated, that the Mitrika was referred by nicknames that only the defendant knew, the timing of the text messages, and that they described the victim and the Mitrika by the clothes they were wearing at some point, that they belonged to Mr. Brown.
Okay.
And that was enough to authenticate the
And
text
the
message.
reference to the nicknames, right? Did he say that?
Yeah.
Okay, yes, very good.
But, Your Honor, I would argue that that's just not enough to authenticate these text messages. Bandwidth.com, text now, anybody can get those, anybody can hide. And without more proof, those text messages just should not have been introduced. And of course, those text messages were used against Mr. Brown to convict him. And that goes towards my sufficiency of the evidence argument, is that with...
So even, I think Judge Greenholz was kind of getting to this at the beginning of your argument, even if we exclude the text messages, I mean, our Supreme Court has made it very clear that even the uncorroborated testimony of the victim is sufficient to establish identity and sufficient to establish sufficiency of the evidence. So it really becomes a credibility question of the victim versus the defendant. So even if we throw the text messages out, how do we get past the victim saying he's the one that did it?
Well, Your Honor, I would say that the victim was not able to identify Mr. Brown in the courtroom. That would damage her credibility. If she was the only one who witnessed the offense, which is what happened, apparently what happened.
She identified him by name, though, right? And the mother was able to come back and identify the defendant particularly.
Well, and that will go towards the defense that was raised at trial, that TG was just making this up. Maybe she just picked Mr. Brown out of the multiple boyfriends or significant others that Demetrica was seeing throughout the years.
In the trial court, that's a good argument, perhaps. In this court, though, given the deferential standard of review that we have, how do we get past the standard of review? Because we have to credit her testimony, because the jury did. I think we have to credit the mother's testimony, as the jury may have. How do we go back in and reweigh credibility issues? How do we go back in and reweigh the evidence testified to by the parties?
Your Honor, my argument was going to be that, the standard is that, if any rational trial of fact based on the evidence introduced at trial would have found that Mr. Brown
Could have found
Mr. Brown guilty. And I will argue that no rational trial of fact could have found him guilty of this offense with the evidence introduced at trial, the text messages and the lack of ID, and that was going to be my argument.
Sure. I mean,
But-
even if we credit the victim's testimony, as we're required to do, I believe, and even if we credit the mother's testimony, as we're required to do. So if that's taken as a given, no rational trier of fact could find the element of identity beyond a reasonable doubt. And I have to discard all countervailing evidence under the standard of review. No rational trier of fact could find the essential element of identity beyond a reasonable doubt.
And, Your Honor, with your question, you are saying that you're going to credit what the victim and the mother are saying.
It's not me. I think the law requires us to. I think the standard of appellate review on the sufficiency of the evidence requires us to credit all the state's witnesses. and it requires us to discard all countervailing evidence. And it requires us to view the evidence in a light most favorable to the state, and to draw all reasonable inferences in favor of the state's proof. And that's a tough standard. It's a high standard. That's the standard we have from Jackson versus Virginia. And I think maybe the question I have might be that if that is the standard of appellate review, and we must credit the victim's testimony, and we must credit the mother's testimony, no rational trier of fact could conclude that the element of identity has been met beyond a reasonable doubt.
Beyond a reasonable doubt, no, Your Honor, even if those witnesses were credited because of Demetrica's multiple boyfriends she had throughout the year, the time span that had passed, and
Does that weighs against the mother's credibility, then I take it?
yes, Your Honor.
Once again, we have to accept her, have to find her credible, I think, under the standard of review. Because the standard of review requires us to credit the testimony of the state's witnesses. You're doing very well with your argument.
Thank you, Judge.
but what I'm
He's
asking-
put you in a box,
it's-
unfortunately.
It's a tough
No, you're doing very
question.
well with the argument. So the argument itself, though, is that the text messages are inadmissible, and that the text messages were essential to a finding of identity, and that without the text messages, identity can't be established.
Yes, Your Honor.
Okay, very good.
Well, Your Honor, speaking of credibility as to the, Demetrica, there was some DCS records that were not introduced at trial.
So what's in those DCS records?
That was let's see, if I remember correctly, it was a case against Demetrica.
Well, your argument is, if I understood it, is somehow that it's material to the defense because it went towards the mother's credibility in some level.
Yes, Your Honor.
So I guess my question, though, is what did she do? What's contained in these DCS records that make the mother not credible?
Well, Your Honor, I think that might be the issue at hand, is that we actually...
You don't know what's in there?
We don't.
You still don't know what's in there?
No, Your Honor.
Okay, all right, that makes sense. Okay.
But I would argue that, the state would have had a duty to inspect those DCS records and see if there was...
So the state makes an argument that your client was aware of the DCS records, and therefore they don't have a duty to disclose what you're already aware of.
The way I understand Brady, I don't think that is true. If it's exculpatory, they always have a duty to disclose that, whether we even ask for it or not. Especially if it's obviously exculpatory, then they definitely need to turn that over to the defense, and so they can use that in their trial. And that's what I'm arguing here.
One of the other bases of Brady, though, is that the state would not be required to disclose even exculpatory evidence if it's otherwise equally available to the defendant. I think that's what the state's arguing. The state's arguing that it was equally available to the defendant because the trial court made a statement on the record that it would have granted a motion or would have given access to the DCS records had trial counsel simply have asked. What's the response to that?
Your Honor, I think that it kind of goes back to the state's duty and what they need to do. If the defense had equal access the way that the state does, which I don't think they do, then sure. But in this case, these are DCS records, these are state records, they're under the possession of the state, and I think an investigation should have been done to see if there's anything exculpatory that should have been handed over to the defense. And that would have gone to credibility, and this is a constitutional error. And if your honors do find that an error had occurred, then I would ask this case to be remanded for trial, so we can get access to those records and have that trial. And Your Honor, my final argument is that Mr. Brown was sentenced to 27 years. 2 years above the minimum of 25 years for a rape of a child. I think that the trial court misapplied the sentencing factors when it found that Mr. Brown was engaging in criminal conduct when he sent those text messages. But as I previously argued, it was never exactly definitively proven that Mr. Brown sent those messages.
Of course, those aggravating and mitigating factors are advisory only. Did the trial court go through the Sentencing Act and what's required in making the sentence?
I believe so.
Other than the factors, I'm talking about the purposes and principles.
I think it was briefly touched on by the trial court, but they didn't go into too much detail about the guiding principles of the Sentencing Act, mostly just the sentencing factors. And, Your Honor, I think that's my time.
All right, thank you.
Thank you very
Thank
much.
you.
Thank you.
Morning, Your Honors. May it
Morning,
please the
Jim.
court. Garrett Ward here today on behalf of the state of Tennessee.
Mr. Ward, I just want you to know, I realized after it came out of my mouth a few minutes ago and I said something about your brief, I did not mean that disparaging. I mean, I couldn't find the words and I couldn't remember how you said it, so I was just,
No offense taken, Your Honor. If there comes a day where I look at a brief and I think I have stated all my positions with the most grace, I'll be pretty surprised. I'm going to start here with sufficiency of the evidence. This court should find that the evidence was sufficient. The dispute here, Your Honors, chiefly seems to be about identity, so I won't sort of relitigate and rehash all the proof at trial about the facts of the rape itself. As for identity, the state essentially had a two-step identification here of the defendant. Step one was the victim's testimony. The victim's testimony was, when I was 11 years old, I was raped in my home bathroom by a man named Willie Brown, and that man was my mother's live-in boyfriend at the time. Then, later at trial, the victim's mother stands up and testifies that, well, when the victim was 11, my live-in boyfriend named Willie Brown was the defendant and identifies him in court. Judge Greenholtz, as you identified under the sort of Jackson versus Virginia standard, this court is law bound to accredit or to give full credit to the testimony of the victim and her mother when it comes to identity, and giving full credit to those two pieces of testimony from those two witnesses. A reasonable trier of fact could easily find that identity was clearly established. We have an in-courtroom identification, specific name, specific relationship identifying the defendant as the perpetrator of this act.
you're saying it's proven even without the text messages?
Easily, Your Honor.
Okay.
We have identification of the attacker by the victim by name and relationship, and then we have the mother's testimony saying the person with that name, Willie Brown, with that relationship, my boyfriend when the victim was 11, that is the defendant.
So if that's
irrespective of these text
if that's
messages.
the case, and the burner phone let's just say that's what it is. The burner phone, there's no proof of who owns the burner phone. So there's no true proof of authorship. Why do we need the text messages?
Well, a couple of points on that, Your Honor. I want to say that, when it comes to sort of differentiating sort of why is certain evidence introduced if it is not, legally required for sufficiency. Sufficiency review applies every deference possible to all of the state's evidence. But a jury doesn't have to do that. The jury, perhaps if the jury is presented with sort of an incomplete picture of the evidence, presented with less evidence, a jury might not accredit all of the state's evidence. So yes, legally this in-courtroom identification is sufficient, but I certainly would not advise any prosecutor trying a case to just introduce the bare minimum to pass the sufficiency standard.
That's not really, I guess, I understand why you answered the way you did. Inartful question on my part. But why do they come in if we can't prove authorship?
So
Is a better way of asking.
on that specifically, Your Honor, I want to draw a little bit of a differentiation between authenticated and between authentication and authorship, because I don't agree with the assertion that there is simply no proof of authorship in this case. There's not perhaps definitive proof, but a pretty long line of cases from this court, starting with Vermaine Burns about 10 years ago, and maybe culminating in a recent case.
Hamer's different. Hamer's different.
Hamer is different.
Hamer's different, and the reason Hamer's different is because that was also a two-step authentication, and the witness who received the text messages recognized the defendant's telephone number, did know, as you say here from the content of the conversation, who he was talking to, but the person who received it identified the telephone number as being the defendant, and that's not here.
That's certainly the case, Your Honor, and I'm not trying to say that there's, a dozen cases out there with the exact same type of authentication proof as we have here, but the through line from Burns to Hamer is that definitive proof of authorship is not required. The authentication bar is sort of sufficient evidence under 901, sufficient evidence for a trier of fact to conclude that, the evidence is what the state is suggesting it is. So some proof of authorship, but not definitive proof. And I think that's sort of an important table setting exercise before we actually look at the authentication proof here. I think chiefly, Your Honors, in this case, the authentication proof is the use of these pet names. These text messages were sent to Demetrica. She read them. She saw that she was referred to by a couple of pet names. She testified on the stand. She testified to the trial court in an authentication hearing that the person that refers to me by these pet names is the defendant. That is.
I guess my concern is that there's actually three people, maybe more, but three people we know of that know the pet names: the defendant, the mother, and the victim. And if the text message is going back to some website that we can't prove who sent the message, I mean, when there's three people who could use the term, and those three people also know the quote details of the alleged rape. So, and I can't prove that the defendant is the one who used the website or used a burner phone or whatever. It makes that evidence to me suspect.
Mm-hmm.
So, isn't it at some level therefore unfairly, well, it may be probative, it becomes unfairly prejudicial in the sense that I can't establish who actually sent it. I can talk about, hey, it probably could be the defendant because of the pet names and because of the understanding of the crime, but two other people know the pet names and the understanding of the crime.
And Your Honor, to some extent, it seems like the discussion of authentication in this case is bleeding into some other evidentiary rules. I heard you mention, well, maybe isn't this unfairly prejudicial? That's not a 901 concern. That's a 403 concern. And the challenge to the admission of this evidence, as I understood the trial objection and as I understand the motion for new trial in the brief, is that it wasn't authenticated. So, maybe there was an argument to be made that, oh, well, we don't actually know who sent this. There's these pet names. Maybe it could have been the defendant, but that seems pretty unfair. That is a great concern for a trial court and for this court to have on a 403 analysis. It doesn't really play into a 901 analysis, to an authentication analysis. That is cabined to, is there...
Can we review it under 403?
Pardon, Your Honor?
Can we review it under 403?
It hasn't
been asked to, have we?
Hasn't been raised, Your Honor.
I didn't ask you.
I believe Judge Greenholz has excellent insight into that. It hasn't been raised.
Wait till you ask your next question.
I'm sorry. It's very important to remember seniority on the court. Well, I mean, we this court has held, for example, in the context of letters, State versus Lowe from 2018, that a letter can be authenticated based upon the contents of the letter, and that where the contents of the letter show that it is what the proponent is claiming that it is, and that's a letter from the defendant, that the authentication test has been properly admitted. As I understand the state's argument, that's exactly what you're arguing here, right? That the authentication comes from the contents of the text messages. And that while we might not have it beyond a reasonable doubt, it's sufficient evidence to show what the proponent, what the state claims that it is. And those are text messages from the defendant based on the contents.
That's the position, Your Honor. Right? You know, we have in any of these cases where the state is trying to authenticate, you know, words, whether it is in a letter, in a text message, you know, social media message, it's almost never going to be possible to prove beyond a shadow of a doubt who typed the message, who wrote the words on the piece of paper. There's always going to be some sort of quantum of uncertainty as to the author. And that's why this court has consistently held, you know, for the better part of a decade now, that definitive proof of authorship goes to weight. These complaints about authorship that, well, all we have are these pet names and the context, and other people can know that. That is a weight argument, not an admissibility and authentication argument. When it comes to authentication, the evidence the state put on that suggests these were a series of text messages sent from the defendant to the mother is sufficient for authentication purposes, which is the legal doctrine that has been you know, sort of put forth by the defendant as the problem with the admission of this evidence.
So let me ask you about the DCS records.
Certainly, Your Honor.
I don't know if you or Judge Greenholz wants to answer the question. I'll direct it to you. So one of your positions is that it's not a Brady issue because the defendant had access to the DCS records. So I guess two questions. One, how does the defendant, who is not the biological parent, have access to the DCS records? And maybe the second question answers part of the first question. What's in the DCS records?
I'll address the second part first. I have not the foggiest idea what is in these
Okay.
DCS records.
Were they reviewed in camera by the judge?
No, Your Honor, and Judge Holloway, that's sort of the problem here. The defendant in this case had access to these records under sort of an in-camera review request procedure. It's outlined by this court. I believe the case is Ritter, but it's applying a U.S. Supreme Court case, Pennsylvania versus Ritchie. And essentially what the defendant would need to do, because the defendant certainly was aware of these DCS investigations. He is the person who brings them up at trial. So he has awareness of the existence of these DCS records, of these investigations. All he had to do was ask the trial court to look at the records of DCS, which these records are sort of beyond a shadow of a doubt. These records are confidential. The trial court, though, could review them in camera and see if there is any exculpatory information and then give it to the defendant. And that is exactly what the trial court said it would have done. Maybe not in as many words, but that's exactly what the trial court said.
Your point is he didn't have access to them as he could have just gone and gotten them because he's somehow related.
Right.
He had access to a mechanism of the court that allowed it in camera review.
Correct, Your Honor. These are confidential records. He couldn't just walk into DCS and request them, but he could have asked the court to look at them for him. He didn't do so.
So your friend's argument, though, is that it wasn't required to do so, is that if the state, in reviewing the DCS records, had itself concluded that there was exculpatory information, they would have had the obligation to disclose it immediately. What's your best response?
My best response, Your Honor, is to point to the Marshall case from the Tennessee Supreme Court that says if evidence is available to the defendant, the state's duty to disclose doesn't cover that evidence.
And so the Ritchie procedures are effectively making it available to the defense?
Yes, Your Honor. We might have sort of a slightly different case if the sort of rubric we were working with was that the state had sort of suppressed any notion of these investigations in the first place. Maybe that's a little different. But we don't have that. We know the defendant knew about these investigations, and all he had to do was ask, and the trial court would have reviewed these records.
Was it not the trial court's responsibility to do an in-camera inspection of these records if they're presented to the trial court?
Not without request, Your Honor.
How did the trial court get them?
It's, from my understanding of the record, Your Honor, it's not clear the trial court ever saw the entire DCS record. This comes up in sort of a muddied way at trial. The defendant attempts to ask some questions about the DCS investigations, not the record specifically, but the investigations. The state, and this is all around page 220 of volume 4, to sort of direct the court to where the most relevant discussion of this issue is. The state, raises some evidentiary objections based on relevance, and then there's a pretty long jury out hearing about these records. The only thing that I can confidently report to this court that the defendant and the state and the trial court all saw was what is referred to in the record as a blur of this file. I take it to be maybe a short summary. I don't know where it came from. I don't know who authored it. I don't even know what this blur says. But in this jury out hearing, everybody's talking about it. Presumably, it touches on some of the facts that the defendant brings up when he tries to question Demetrica about this. But it doesn't seem the trial court ever saw anything beyond this blur. There was never a request for the trial court to do a full review of these confidential records of DCS. And that's really the access the defendant had here that removes this from the state's duty to disclose. The defendant could have gotten this information. All he had to do was ask, and he didn't. But even setting that aside, Your Honor, I think there are other problems with the Brady claim here. I've mentioned to this court previously that I can't say what's in these DCS records, and that's because the DCS records are not in the records of the trial court. They're not in the record here on appeal. There's nothing in this record to establish that these missing records were somehow were even favorable, and certainly nothing to establish their materiality, which, it's the defendant's burden under Brady to meet both of those prongs. We don't have the allegedly favorable and material information. We don't have that to review. So, Your Honors, I'd submit to the court that it's not possible for the defendant to meet those burdens without showing this missing information to someone.
Isn't it even more fundamental than that? I mean, where's the evidence of suppression? I mean, the state can't be held to have suppressed evidence that the defendant knows exists.
I agree, Your Honor. I think, I don't really think there's evidence of suppression. I think that dovetails sort of nicely with this in-camera review procedure we discussed earlier. The defendant was aware of the investigations. The state certainly didn't suppress that. Your Honor, I'm not certain that the state could have just walked into, defense counsel's office and handed him confidential DCS records. I would hope that there would be some safeguards against that. I'm not.
In my experience, they bring them to the judge, and the judge does an in-camera inspection. Anything that's exculpatory, the judge divulges in an order or some type of document.
And that's precisely the procedure that should have been followed here. The judge indicated that, perhaps part of this record would have been turned over had that been done, and it wasn't. But we have no real evidence of suppression, and without knowing what is in this file, there's no real evidence of favorability or materiality. So that's, multiple required prongs to establish a Brady violation that simply aren't met in this case. And I'll turn briefly to sentencing. Your Honors, the trial court here acted within its broad discretion in imposing a 27-year sentence instead of the 25-year minimum for rape of a child. Judge Holloway, you asked, did the trial court, consider the purposes and principles of the Sentencing Act? It absolutely did. Volume 6 contains about a 10-page oral finding from the trial court where it discusses a number of principles, rules, guiding thoughts from the Sentencing Act. The trial court specifically focuses on a couple of the advisory enhancement factors, namely abuse of a position of private trust and criminal history. The defendant suggests that perhaps these principles were misapplied in a way that means the trial court sort of wholly departed from the purpose of the Sentencing Act, and that's just not the case.
Just as an academic matter, though, with respect to enhancement factor 1, is there any other evidence of criminal behavior aside from the text messages?
Not that was brought out in this record, Your Honor, but the text message,
I thought there was some testimony that he drove by the little girl and made a comment out the window or something.
So there was that. That's sort of almost part and parcel with the text messages. I do believe there is this episode of him that the child testifies about him driving by and making some comment to her. I don't
know where you live or something like that.
Something that might be creepy, but maybe not outrightly criminal. So, but when the trial court does apply this criminal history enhancement factor, it looks not only at that episode, but the contents of these text messages, which are rather disturbing. Some pretty explicit threats to kill the victim in retaliation for, revealing this assault. These are, and they're repeated on 2 or 3 instances. These are texted to the mother with sort of specifics about, I know where you live, I know when you come and go, I told her not to tell. If anyone tries to stop me, I'll kill them too. This sort of behavior meets the elements for electronic harassment is perhaps the criminal statute I can think of that most closely resembles this, but that is criminal behavior. Trial court appropriately considered it, and then the testimony was that the defendant was essentially her stepfather for this period of time. That's a position of private trust that was abused to perpetrate this crime. If this court has no further questions, I would ask you to affirm the judgment of the trial court.
Thank you, General.
Thank you, Your Honors.
Mr. Garcia, I'll give you a short opportunity to make rebuttal, if that's okay with my fellow judges.
Yeah, certainly.
Yeah.
Your Honors, I would like to focus my rebuttal on the authentication of the text messages. I understand that there does need to be some proof of authentication to have text messages admitted into evidence, but it needs to be sufficient proof. And I argue that there was not sufficient proof to authenticate these messages were from Mr. Brown. I think that there definitely were some threats sent to Demetrica and TG, and they referred to them by pet names and by clothing, but I argue that that's just not sufficient proof that Mr. Brown was the one who sent that, especially when there are 2 other people who knew about this offense. Really, one, if Mr. Brown is innocent of this offense, then it's just TG who knows about the offense and what happened. And I understand that this court, under the sufficiency of the evidence, must credit the testimony of TG and also of Demetrica, but that alone, without the text messages, would probably not have sufficed to, I argue, would not be sufficient to convict Mr. Brown based on, especially based on TG's not being able to identify Mr. Brown in the courtroom after she had opportunity to examine everybody in the courtroom after the judge told everybody to pull their masks down, and she still could not identify Mr. Brown, who allegedly raped her and who TG would have very obviously seen.
If the text messages were inadmissible and that the trial court erred in allowing them to come into evidence, can this court still consider the text messages on a sufficiency of the evidence review on appeal?
If they were excluded?
No, let's say that they were admitted at trial, but let's say that we find that they were erroneously admitted. Can we nevertheless consider the erroneously admitted evidence under a sufficiency review?
That I'm not too sure, Your Honor. I'm going to be honest. I'm not sure if you would be able to, but I also like to point out about the sentencing of 27 years that Mr. Brown was sentenced to. Mr. Brown has no previous criminal history. He has a clean record. And I argue that the position of trust that the trial court imputed on Mr. Brown perhaps was a little bit misconstrued. I don't think there was enough evidence to really show at what level of trust that Mr. Brown was in Demetrica's life and TG's life. It might have been a good relationship, okay, might have been a very bad relationship, but I don't think that it rose to the level of trust and not to the level of being the victim's stepfather. And I will argue that 27 years is excessive. If the conviction must stand, then Mr. Brown should have a minimum sentence of just 25 years. Thank you.
Thank you.
Thank you, Mr.
Mr.
Garcia.
Garcia, thank you very much. We look forward to having you back.
All right, that concludes the docket for Jackson. We'll be taking these cases and sending out